Thank you so much for being with us here on Market Day Report. I'm Tammi Arender. Swampbuster rules were enacted in the 1985 Farm Bill to prohibit the conversion of wetland to crop production. A recent court decision said a farmer wasn't entitled to a review of a prior wetland determination, leaving open questions on the table. Roger McEowen with the Washburn School of Law joins us now with more perspective. Roger, good to have you with us. Let's start with some background on the Swampbuster rules and how they work and how they've changed over the years.
Well, good to be with you, Tammi. The Swampbuster rules came in with the 1985 Farm Bill, and in general, they prohibit converting farmland to, or converting wetland to crop production farmland if you want to receive farm program payments. You can't do that. And there's only a couple of exceptions. One would be for prior converted cropland. But if you're determined to have improperly converted wetland, you can't get program payments. But basically, to be a wetland, a tract has to have three things: hydric soil and hydrophytic vegetation and wetland hydrology.
So what have been some of the recent legal issues with these rules?
Well, there was a big change in the rule in 1996. It's known as the Grassley Amendment, and they changed the rules then to curtail attempts by NRCS to frequently change wetland delineations. That's when they started changing these delineations and making delineations by aerial photographs. And the farmers were getting kind of whipsawed around. They'd get one delineation, then it would change, then it would change back. And so the Grassley Amendment said that prior wetland delineations stayed in place and could only be changed if a farmer requested it. But the statute didn't say anything about NRCS having the ability to write a rule saying, well, you can only request a redetermination upon satisfying certain conditions. Well, you had a South Dakota farmer that wanted a redetermination, and NRCS said initially, well, the first time he asked, they denied it, and they came back a second time and had engineering reports and had reports of soil types, which in the NRCS book didn't even qualify as a wetland. And he also had various types of maps, and the whole issue involved 0.8 of an acre of a puddle that wouldn't drain anywhere that was created, get this, by one of his ancestors that planted conservation tree belt at the insistence of NRCS back in the 1930s. And of course, snow would collect up under those trees and then it would melt in the springtime, and half the time you couldn't farm the field. And they said, well, that's a wetland. And he lost his case because basically NRCS said you haven't established any changed conditions. And it was a battle over the regulation and whether NRCS could write a reg like that. And the court said they could.
Wow. So what was the final court's ruling on that?
Well, they said NRCS could write a rule specifying conditions for review and that the rule was reasonable and that he hadn't provided evidence of changed conditions that would justify a redetermination.
And so the biggest takeaway here for farmers?
Big takeaway is pretty difficult to beat a government administrative agency. Now, there's a Supreme Court decision coming next term that could take away some of that deference given to government agencies. And Senator Mike Rounds in South Dakota has introduced legislation addressing wetland compliance matters. So that's the big takeaway, and maybe the court and the Congress will deal with the issue.
All right, that's Roger McEowen with the Washburn School of Law. Thank you so much for bringing us up to date on that.